Everybody. We're going to do a quick one here right before the Lori Vallow sentencing, which is happening on the 25th of July, 2025. This is the 24th as I'm recording this. So I looked over the aggravating factors that Arizona has listed in their statutes, and I have my predictions as to which ones Judge Beretsky will add, in addition to the ones that Lori has already stipulated to. Because the 14 that are listed, not the same wording as she stipulated to in court. So let's talk about it. If you're new here, I'm Annette Lyon, USA Today bestselling author of the suspense novel Just One More and a whole bunch of other stuff. True crime junkie, woman of faith, which also means respecting other people's faiths, including my own, which is the Latter-day Saint. So thank you, and moving on. Lori Vallow obviously has been a big case I've been following for a very long time, since it first broke, because Chad Daybell, as you know, was in my publishing industry world as Latter-day Saints. So here are the three aggravating factors that Lori already stipulated to in court. That the offense was dangerous, obviously. And we're talking about both the Charles homicide and the Brendan Boudreaux attempted homicide. Those two cases, she's being sentenced for both on the same day, July 25th. 2025. She stipulated that the offenses, she stipulated on both, they were dangerous, involved an accomplice, and caused emotional or financial harm to the victim/victims' families. She already stipulated to that, but as we were hearing, the judges can add more aggravating factors in addition if they so choose. So I went looking and digging and found some things that I think are interesting. And factors that wouldn't apply in Arizona, but oh dang, they could apply elsewhere or in a different case that anyway. We'll get to all that. There are 14 that Judge Beretsky could theoretically add. Assuming that those three don't fall under these somewhere, I'm not a lawyer, not a paralegal, not a professional in that arena of any kind. These are totally just layperson opinions. Again, true crime junkie, writer person, this is my guess is. We shall see. First one listed is if you have a prior conviction for life imprisonment or death. And so I'm first looking at this, it's like, oh, that sounds like this would apply, because she has 3 life sentences waiting for her in Idaho, right? But not so fast. It says that this applies only to if the date of the prior offense occurred before this one that she's being sentenced for. And since Charles died before any of the others, I don't think this one applies. Interesting how Brandon is the last. He was the last attempted homicide in all of this. Now, will she be sentenced for Charles, and then this one could have then applied to Brandon because she was just sentenced for the Charles, and that event happened before Brandon's attempted homicide? I'm guessing no, but that's a maybe. That's a possibility. So we'll see. But I'm gonna say, just to be safe, I'll say no. Of the 14, guessing not. This one, number 2, the defendant has been or was previously convicted of serious offense, whether preparatory or completed. So whether the offense was completed or not, the person has been convicted of prior offenses. It doesn't say within the state of Arizona. She obviously has been convicted of serious offenses. So I think this one would count. I think absolutely. And if you factor in the Charles and the Brandon thing, if the first one doesn't count, this one I think would absolutely fall under that. So number 2, I think will count. Number 3, grave risk of death to others. So again, this feels like the danger one is a dangerous offense that she stipulated to, but it's not worded the same. So I think it's something else. This is an aggravating circumstance. In the commission of the offense, the defendant knowingly created a grave risk of death to another person or persons in addition to the person murdered during the commission of the offense. So this is arguably true because Tylee and JJ were nearby. They easily could have been caught in the crossfire, which is why she tried to shuttle them off, but they could have been hurt too. So I'm thinking he will probably add that one. So 2 so far, 2 of the 3. Number 4, this is interesting. Procurement of murder by payment or promise of payment. If the defendant procured the commission of the offense by payment or promise of payment of anything of pecuniary value. So it sounds like just like it's a murder for hire situation, but apparently it's not just. It started out that way, I think, when it first began. It says here, I think it was in 1973, but then it was then broadened to be beyond murder for hire situations. That aggravated factor 4 and 5 were both considered to be murder for hire. Number 4 was the person who did the hiring. Number 5 was the hitman. but now they've both been broadened. So number 4 can be murder for hire, as well as more than that. So, and for the record, pecuniary just means financial money gain. So thank you, Merriam-Webster. 3. So far we're doing good, but we're going to be running out pretty soon of ones that apply. So I think we do have 3. We have 3 down, 3 out of 4 that we've gone through out of the total of 14. Number 5 is the other murder for hire one. Originally written and interpreted as the hitman in the murder for hire situation. It has been expanded. If you receive anything or expect to receive anything as a result of doing the murder, however, getting that thing has to be the motive. There must be proof that the murder would not have occurred but for the defendant's pecuniary motive. So if the expectation of pecuniary gain is a motive, cause, or impetus for the murder and not merely a result of the murder, then this factor has been proven. It doesn't count if someone committed murder and then, oh, I didn't even know they had a life insurance policy, party on. I didn't realize they left their house to me. Oh, that's a nice, side effect. I didn't know it going in, and or it wasn't a motive. So it's not enough that Lori gained from it. It's that she would not have made this happen without that motive. So yes, I think as we know, money was a huge motive. Money, power, and sex, right? In all these cases. To make Alex do it, to send him off, and to collaborate and plan this whole conspiracy and to carry it out. So 4 and 5 both apply to her. Sorry. So we've got 4 out of the 14 that apply. We've gone through 5. Now we get to the whole chunk of them that I don't think, no matter how much we would like it to apply, would not. Heinous, cruel, or depraved manner, and that the crime was committed in one of those fashions. I will not go into detail. This is not only is it's triggering and all that nastiness, but we don't need to discuss gory details. Examples, just talking about the victim's mental or physical anguish, how long and drawn out was that pain, the type of death that was done, pleas for help, defensive wounds, that kind of thing. These are victim-oriented factors that would come into particularly heinous or cruel. I said that these used to have 5 factors from the perpetrator or defendant's state of mind, and they added a 6th as well. So relishing, and they have whole paragraphs describing specific cases where this would apply and examples, but essentially someone who is a sadist and enjoys watching someone suffer and watching this thing play out. So that would be the relishing. Gratuitous, I'm putting some asterisks in here just for the sake of platform friendliness. But gratuitousness of the crime, so overkill, things that didn't need to happen, that you're hurting the individual, and that it may or may not be causing significantly more pain or time or whatever, but you're doing more than needed because it's way more than the actual crime would require. Similarly, the needless, I'll call it destruction of the body, put it that way, senseless or unnecessary. And then I had to read further because I'm like, and then unless it's like self-defense, all homicide is senseless or unnecessary, isn't it? But it's to achieve whatever goal the perpetrator had. So it was like, if I just want to get rid of this person, I shoot them or whatever. But if they had a goal to, say, rob a bank, and they went in and started just taking bodies, then that would be senseless, unnecessary. A lot of these overlap, of course. Victim helplessness, and there's some definitions in there if a victim is particularly young or old or disabled, tied up, or whatever. And then also they realized that witness elimination would fall under this as well. Someone is completely innocent and just happens to be the wrong place at the wrong time. Unfortunately, I don't think any of these apply. As much as we would like to just add every possible aggravating factor, none of these seem to apply. The only one that would apply even in Idaho would be victims when it came to Tylee and JJ, or actually probably only just JJ. We'll get to the specific on that in a minute. Number 7, committed while in custody. No, that all has happened before she was arrested. It's either while you're in prison or if you're on parole, probation, whatever, and that's when you commit the crime. That's an additional aggravating factor, not applicable here. Would be applicable to James Craig though. Just saying. He's got a lot of aggravating factors and new charges from that kind of thing. So watch the James Craig playlist. I'm having a new one coming up there soon. Doesn't apply for this one. Multiple homicides. In committing this particular offense, more than one person dies. And in this particular time, it was just Charles. So again, to go back to Idaho, this would be an aggravating factor when you're talking about a trial like before JJ and Tylee and Tammy, but down here it's just Charles and then later Brandon, and only one person died. So this one would not apply. Age of the victim, this is what I was referring to there. The person is over 70 or under the age of 15. In Idaho, if this aggravating factor applied, and I don't know if it does, I'm just looking at Arizona, this would apply to JJ, but not Tylee because she was almost 17 at the time of her death. And then if the victim's a peace officer, obviously that's aggravating factor in most states, if not all, but not relevant here. So 11 and 12, for some reason, they're listed together. The first one is RICO statute type things, mob gang related activity. The other one is retaliating, witness tampering, that kind of thing. I don't think either applies unless they could have proved in court that their cult stuff would be considered an organized crime situation, which frankly, I think you could argue it, but it hasn't been proven like that. And that's a slippery slope in the sense of once you start bringing in faith, religion, whatever, then people can start throwing out RICO things at actual churches. So that would not be cool. So, freedom to worship as you wish that's an issue. But so this one doesn't apply either. Number 13, I think this one might. That the crime was committed in a cold and calculated manner, without pretense or moral or legal justification. That's the only part that could be a hiccup, in my opinion, because Lori, in her delusions, likes to justify it with her own little moral compass and her own moral justifications, but those aren't real. She was so nonchalant. She was so nonchalant. So if being nonchalant, and if you read the rest of the statute, it gives examples of calculated and planning, meticulous, or just not emotional about the whole thing. It was controlled. All of that seems to apply. She was not falling apart. She planned this in advance. She was nonchalant. I think that might count. I think that might apply. Number 14, use of a remote stun gun. If a defendant used a remote stun gun or an unauthorized remote stun gun. I find that interesting. Obviously not the case with Charles or Brandon, but it makes me wonder. We do know that Joe has a stun gun used on him by Alex, and that Alex did some time for that, and that Joe died in what we now look back on as suspicious circumstances. Joe was Lori's third husband, and they can't do an autopsy because he was cremated, and by the time they found his body, he had been dead in his apartment for a couple of weeks, so he had decomposed too much to see much or be able to determine anything if they ruled it natural causes. Alas. I think most people who would be found in their apartments, it would be, but we're talking Lori, who had previously said she wanted him dead. And I know the Joe's former lawyer, who helped represent him during custody battles with Lori and nastiness there, he said that in his opinion, the stun gun could have weakened his heart and maybe contributed to a heart attack. At minimum, in my opinion, I do think that Lori had something more to do with Joe's death. But again, we probably will never know for sure. So that one can't apply to Charles and Brandon. So again, here are the three that she did stipulate to. The offense was dangerous, involved an accomplice, caused emotional or financial harm to the victim or victims' families, and the ones that I think Judge Beretsky could add. The conviction of a prior offense, grave risk of death to others, procurement of by payment or promise of payment, conviction for pecuniary value, and a cold calculated. And that's actually a 5. I wrote 4. I meant 5 because maybe if that first one counts. I don't know. We shall see. So let me know what you think. What are your predictions? Do you agree with me? Do you not? And will any of this matter in the end as far as how much time Lori spends behind bars? No, technically no. She will be behind bars for the rest of her life regardless. It is an insurance policy, so if something bizarre happens in some appellate court with some judge somewhere and the Idaho convictions get thrown out, she'll still be behind bars in Arizona instead. It's also honoring the victim so that everybody gets their sentence and their justice. I'm grateful that Brandon got his and that he's still with us. So I would really love to maybe see some justice for Joe. I would love to know what actually happened to Tylee. Will we ever find out on either of those? I doubt it. Lori and Chad will never speak or be honest about any of these things. I think we're at the end of the road when it comes to Daybell content, unless they get one of them dies in prison suddenly, or they're attacked, or something major weird happens. If they put a hit on someone from prison, or if Zulema or Melanie Pulaski gets charged, which, we can hope. But yeah, let me know what you think. Do you agree? Do you disagree? Are you going to be watching the sentencing? It's interesting. It's kind of wild to think that we're, after so many years, we're at the end of this. So while you're here, give the video a like, subscribe if you're new, hit the notification bell, all that good stuff. It really helps the channel and it means so much. So I'm going to do one more quick video here before I go get myself some chocolate. So you go do the same.